You're welcome back to Newsfile. This is your most authoritative news analysis show. And here are some of the messages that you have sent. Kwame Sapong Esiedu says, I am on the Ghana Electoral Register. I registered using NHI card. In the ongoing limited registration exercise, I act as guarantor for a person without any form of ID who subsequently gets on the register. By the ruling from the Supreme Court, if I have to be deleted and given the opportunity to re-register, should this new entrant be removed too? Okay, it's a question that he puts it far better, but many people have also asked on the platform. Then there's a position that this friend of my police lawyer has been advancing since the decision was made. He was in court. He says deletion of names in any form cannot be prospective. The cards were central to the issues. The authority has responsibility over the cards. The court has a duty on its own to order the authority, that's the NHIS, to resolve the question of nationality at the point of subscription with least political resistance. So he feels that that should have been a better solution. Simply ask the NHIS to redesign the card to be like the driver's license. And then Krobia Asante Kotoko says proposal to Electoral Commission. The EC has district offices dotted around the country, and every day a sizable number of persons turn 18 years. So there is no need for us waiting for 4 years to open limited registration exercise to register the backlog. What major work does the EC, especially district offices, do after general elections? In this regard, I propose any person who turns 18, upon satisfying the constitutional requirement, could walk into the EC's district office in his or her catchment area and register. And he says these are the benefits. Low or no political temperature. 2, less partisanship. 3, no need to beef up security. And 4, less or no minor registration. This is worth considering. And that is from Krobia Asante Kotoko. That's the name of a person. That's a whole, title.
Right.
And it's interesting what he says. If you read the earlier Abu Ramadan case, this is what the Chief Justice said. The need for a credible and reliable multi-purpose national identification system comprising the relevant data and communication infrastructure that would answer to most of our national needs, whether for electoral, planning, or developmental, or other purposes, is greater than ever before. We think the time has come for the appropriate authorities to respond to this need.
Yeah.
Doc, how would you answer the question of people who registered in 2012 using NHIS, and now, because they have an ID card, voters' ID card, are guaranteeing for other people?
Oh, thank you. The question actually brings to the fore my concern with the position of the Electoral Commission that it can confer citizenship on persons by virtue of confirmation by at least 2 Ghanaians. And it is wrong, it is against the law if you look at Article 6 of the Constitution and also the Citizenship Act. So citizenship by virtue of confirmation by 2 Ghanaians is not consistent with the law. And it's one of the procedures which have been adopted as part of the registration if you don't have any evidence of citizenship. that by getting 2 Ghanaians to come and confirm that you are also a Ghanaian.
It was in Regulation 11 of CI 72.
Yes.
It has been repeated in CI 91.
91. But if you look at the Article 6, you are a citizen of Ghana if you can trace your lineage to a parent who is a Ghanaian or a grandparent who is a Ghanaian. So those persons should, the ECE should have actually focused on letting those persons establish their parentage through their mother and father or through the grandparents. Instead of they not showing evidence of that through other persons. Because if you are living in a community and your grandfather hails from the area, grandfather can go very far. Then other people can come and confirm. In that case, then you are short of registering a citizen than just saying that you show up and then you have 2 persons who you could just connive with in your bedroom coming to confirm. And they will come as Ghanaian citizens, that you are also a Ghanaian. And that is the challenge with the practice of the EC. I had a chat with Professor Kumado on this issue of citizenship. And he said that this is a fundamental flaw of conferring citizenship on Ghanaians who are not Ghanaians. On non-Ghanaians thinking that they are Ghanaians because of the act and confirmation of such persons.
Now, Honorable, is the wisdom in allowing that, was it not because many Ghanaians, particularly in the hinterlands, cannot have or do not have a passport, a driver's license, a national identification card, or some other, birth identification processes? That's why you put that there. But now you discover that is problematic, don't you?
That is not problematic. But your question is right. That is fundamentally the reason why Parliament in crafting laws take into consideration certain realities of a majority of the people of this country not circumstanced in situations that will let them have, documents that can prove their citizenship. Now, how do you deal with that situation? The objective situation on the ground is that there are people who have been born in this country who simply know that they are Ghanaians by reason of the fact that they have been born. They have never had any documentation. There are those who have even been born in hospitals who cannot trace them.
As a state, shouldn't we insist on that?
Yes, but we're growing. It's a state, we're growing. And because we're growing, we must not close our eyes to the realities.
We're over 50.
Doctor says. No, doctor, yes, but we're growing. We just had, America is 300 years old. But just in the recent years, they had a problem with their elections. And so, no, we are growing. And it's only, when we grow, we improve upon our situation in life incrementally. It might be small, negligible, imperceptible, but we're growing. Now, doctor says that how can 2 people meet to confer citizenship on a person? Indeed, if your 2 family members meet to confer citizenship on you, they're doing the right thing because they're your family members. They know you.
But Honorable, it's not only family members.
Well, in saying so, you must also look at the law, which says 2 people. Why do you think the 2 people will necessarily conspire to do what is illegal? Why do you think that way?
No, but we know what the parties are
capable
of doing.
In doing the NHIS law, we had said chiefs, we had said assemblymen, we had said opinion leaders could confer, could validate, could somehow confirm the citizenship of a person because we had the difficulty in getting people.
And that's what the Supreme Court also had a problem with.
Yes.
The other thing is that what is bringing the confusion, as you rightly point out, may be the part of the judgment that says, and I think we ought to read that again. He says, the judges say, I think where to start becomes a bit difficult because of how it goes.
There's no head notes.
Here they say that as the registrations were made under a law that was then in force. These people registered under a law that was then in force, CI 72. They were made in good faith, and the subsequent declaration of the unconstitutionality of the use of cards should not automatically render them void. The legitimate way of treating them is to have them deleted by means of processes established under the law.
Yeah.
Delete them by means of processes established under the law. I asked Anansi Antibidi to that question. I think it is very germane.
It is.
In view of the fact that these registrations were not effected in breach of the law,
Yes.
the persons affected thereby cannot be said to be benefiting from their own wrong, such as to be deprived of their registration without being given opportunity to be heard. Meaning, if they are going to be deleted, they ought to be heard.
Yes.
And the process ought to be a process pursuant to an established law. Then they end here by saying, as the said registrations were done before the declaration of unconstitutionality in the Abu Ramadan case, Supra, to have their names deleted will have the effect of disenfranchising persons affected by it.
Yes. Something. You see, this brings to mind the concept of visiting the sins of one on another. In the Supreme Court case, the presidential election case, the majority stated that, yes, the presiding officer shall sign. It's clear. But it will be wrong to visit the sins of the presiding officer on the unsuspecting voter. And therefore, the Supreme Court did not render those votes void.
So Shah is May.
Then you come to the recent case of the solicited license. Now the majority in that case, I would say the Supreme Court has held, by the majority, that the sins of a lawyer not renewing his license can be visited on the client, because it renders his instructions to the lawyer, culminating in the commencement of a case, a will, a mortgage. Any document prepared by the lawyer now becomes void. Then we have this one. Clearly, what it is saying is that the judgment is saying you cannot visit the sins of the Electoral Commission, because it was the Electoral Commission that fashioned out that constitutional instrument.
What do you understand to be the process they are supposed to go through to have their names deleted?
Yes.
And
So-
to be given the opportunity to re-register. It says that, here they were emphatic, we think that any person whose registration is affected by the decision in the Abu Ramadan case be given the opportunity to go through the process of registration to establish his eligibility or otherwise, in order that the appropriate remedies provided under the law may be applied.
I hold a position that, and it's consistent with what I've always held, that the persons who became registered voters based on the NHIS card, they cannot have their names deleted automatically. Maybe the lawyers will say suomotu by the Electoral Commission without verifying with the persons involved whether or not indeed and in fact they were registered based on that. And that's why I will go with the initial proposition that was made by Honorable Yunusa, that they must exhibit the names of those that the Electoral Commission thinks or believes had their name on the register per the card, the NHIS card. But I will add that maybe the part I will defer is that you cannot delete their names until they have appeared before the Electoral Commission and actually confirmed. Because then what will be the use? The person may not even hear that his name has been removed. He goes to the post with his card only to be told that your name It's not there. Or
So the process may not be as easy as some suggest.
I think
Or
that
as,
it may need a definitive clarification. Maybe we have to go back to the Supreme Court. The court stating clearly that when we say delete, you delete and inform the people subsequently. But in page
but what
22,
do they need to go and clarify? It says they should be given the opportunity to go through the process of registration to establish their eligibility or otherwise in order for the appropriate remedies provided under the law to be applied.
Yes, but the court has earlier on indicated the need not to punish persons without giving them an opportunity to be heard. The court has earlier on indicated
Let me find out
So-
if Kweku appreciates what it is that this process will be. It cannot be the exhibition process.
Obviously, it cannot be. And that is why in the EC's own statement, in spite of the roadmap, outlining the roadmap that they had agreed on March 18, 2016, they have said that they are now going to study the implications of the Supreme Court ruling. Meaning that that's an admission that the earlier roadmap is inadequate to cure the mischief that the judgment has brought up. So I think it's clear that the conventional approach, there are some useful elements in it. They still may be adopted going forward. But clearly we have a significant problem here. The cards and those who registered with them, it's been clear that it's unconstitutional. I mean, the court itself says why they even came to the conclusion that was unreasonable was because of the continued presence of those holding the cards. You remember they even made a point that if the EC hadn't complied with the earlier ruling by bringing CI 91 and removing the cards, they would have been subjected to possible high crime charges.
Yes.
So we are clear. We should be clear on the cards matter that it ought not to continue there. They ought not to be there. Okay. Yeah. They say existing or applicable laws. No. If there is no clear-cut existing law now, it can be done. Nobody should say that's a mission impossible.
Okay.
Assuming
that's what you suggested, and I think I've heard Nana Santiwidi to also suggest the same.
So let's assume there's none. Are we that incapable of putting in place a law if it means amending this thing again, CI 91, and adding something to it to make it applicable?
That for you is the only way as we see, isn't it?
At this stage, you see, good faith also. If we're all reasonably connected, everybody's driving forward to the goal that we all demand. If the IPAC sits, other stakeholders intervene, it's a very simple thing. You'd first need good faith.
It's not possible for the parties to agree at IPAC. I'm saying, is it not possible for them to agree at IPAC that they may use the processes where they use the adjudication review committees and all of those entities? You know, they have the adjudication review committee, which is made up of directors and selected senior officers at the head office of the Electoral Commission, political party representatives, and representatives of selected civil society organizations. They are the ones that determine all cases of suspected multiple registration.
Yeah, but that's what I'm saying. If there's good faith, we might be able to, drive this thing forward.
Okay.
But if we're going to insist on some very strict entrenched lines, who says we can't bring in legislation at this point in time to drive the process forward? Who says it cannot be done?
All right.
Yes. In totality, I think the media substantially got it right on this issue.
Okay.
And a quick addendum then will mean that the EC should be welcoming. They should sit down with the plaintiffs.
Okay.
You know, anytime a person is aggrieved and then he realizes that you are intransigent in sitting down with him, it aggravates the situation more. And therefore, sitting down with Abu Ramadan and his lawyers will help us find a roadmap to making sure that the judgment
of course, not exclusive to them.
On that note, maybe briefly, a minute each from all of you. What do you say about the court's emphasis and focus on the EC's independence? It does appear that it seemed to have listened to the populace who have issues with the EC, which repeatedly seeks to, say we are independent and we cannot be controlled by anybody. The courts seem to say that they cannot be, proceeding on that tangent. For example, at a point where it said, we wish to say that the independent status of the first defendant, that's the EC, does not make it immune from action for the purposes of declaring that it has exceeded its authority or acted in a manner that, having regard to its unreasonableness, irrationality, or unfairness, cannot be accorded the sanctions of legality in view of Articles 23 and 1296 of the Constitution. What do you say about the time they spent on the EC's independence?
My take is this, that if you look at the Constitution, from Article 1-2, it tells you that the supremacy of our fourth Republican dispensation is actually hinged on the people of Ghana and not on any institution. That's why any act by an authority, the person, an entity can be challenged as inconsistent with the Constitution or the Republic, and therefore null and void. So if you always assert that you are independent, and at the end of the day you are embarrassed in court, it's not going to add anything to your credibility. So that's where they have to get it.
Yes, Honorable, what do you say? They refer to cases like Tenade and the rest. They refer to a situation where they even place an injunction on the EC's processes. And they tell the EC that in appropriate cases, the EC is subject to the control and or direction of this court.
Yes, in the performance of these functions and in accordance with law.
Yes.
They're just restating the point. That when we say we are independent, you are independent, you must be independent within the context of the law. You must be performing your functions in accordance with law. And that if we fail to do so,
we'll check you.
We'll check you. That's what they're saying.
Yes, what do you say about that?
Yes, I've always had a problem with it. Look, I've said that in terms of institutions of state, there's no institution in Ghana which is more independent than the judiciary, for example. And the judiciary, even in spite of the financial, independent, administrative, and the performance of judicial function, it has a body, Judicial Council, that even regulates how they should perform the functions, or how their independence should also work. So for the EC to usually hold, and they even maintain the point, even in court, that they are independent, not subject to the directions and authority of anyone.
But the court said yes, they are independent.
Yes, but then
subject to our
with the very important qualification that when they move out of the boundaries of the law, they will be charged.
Right.
And that we should commend the court. Yes, we should commend the court. Yeah, commend the court because they made important propositions in there in relation to rule of law and constitutionalism. That when you have a limit, you move out of that limit, and the court even admitted that the judiciary also have their own limit.
That is so.
And that when they go beyond it, it should also be declared.
Okay.
But that is what the way to go, and I think we should commend them for that.
Koko, what do you say about that? I've seen you have marked.
Yeah, they walked the tightrope. The Supreme Court walked the tightrope when it came to the independence thing. They gave all sides, drew a very delicate balance, and then came to the conclusion. It was beautiful, the way they went about it. So I think now there's more clarity on this issue of independence, because yes, the EC has some level of independence, and it's stated even in the Constitution. The court agreed with that, but then pointed out that their decisions and actions and things are also subject to the same Constitution. And that's where the court's intervention is triggered. Sometimes you give the examples. The point about the high crime, they made it that if they had violated the perpetual injunction that had been imposed on them, they would have been punished. So I think that we are now clear in our minds. They are independent, but they are not super independent.
Now, we are done with this segment, but briefly, before we just close the chapter on it, Nana Santibedieto is back on the line. I understand that you have some 30 seconds submission to make. What do you have to say?
Yes, thank you. Just on this issue of the effect of the unconstitutionality of the use of the NHIS card. I mean, the court's jurisprudence has been consistent that if a thing or act or omission is declared unconstitutional, it is retrospective. It is not prospective. A thing is always unconstitutional if it is. The fact that it is based on a law that had not then been declared unconstitutional doesn't make it so. So it's puzzling the portion of the judgment that you read because it would seem that the court is saying that in this case, because at the time the law had not been declared unconstitutional, you cannot penalize people who use the card to register. But in any event, I think the resolution is found when the court says that it is unreasonable to continue to have them. So you go ahead and delete them, but give them an opportunity to re-register. And I think that solves the problem of an opportunity to be heard in any event. But that's the only way to
as far as your understanding goes, the EC can on its own just go ahead and delete them, but it should inform them. Is that what you're saying?
Yes, because the order, that's what the court's order says. The court's order, it empowers the EC to go ahead and delete those names, but gives them an opportunity because it would not be right
register.
to register
eligibility.
The final point I wanted to make was on this issue of the limits of the EC's independence. It is true that if it acts outside the Constitution, it can be brought in line, or if it acts outside its own law, it can be brought in line. But there's also, even if it is purporting to exercise discretion,
yes, the court said so.
If it is unreasonable,
yes,
or irrational, that too will attract legal sanction, and that's where our case really was. But the processes that the EC was trying to use was irrational when you consider that its own committee said that it wouldn't work. So it is not just when it is clearly in violation of a constitutional provision or the law that it establishes it, but also when the acts or omissions are so unreasonable or irrational that no rational body would make it. The courts can also strike it down.
Okay.
Yeah.
Thank you very much. Thank you very much for
but the
your
jurisprudence
views
that the constitutionality of a matter goes to the root of the matter is not exactly true, because in the William the Orange case, his reign was held to be unconstitutional by British standards, but the actions of William the Orange were saved. Yeah.
Okay, thank you very much. I just wanted to close this chapter on reading a portion of something the Chief Justice had to say in the earlier Abu Ramadan case about the importance of the process of registration. She says that as a crucial first step to actualizing the right to vote, Ghanaian citizens of 18 years or above and of sound mind have the constitutional right to be registered as a voter. For purposes which are all too evident, exercising the franchise in all public elections and referenda. If the right to vote is important in participatory democracy, the right to register is even more fundamental and critical. It is the golden key that opens the door to exercising the right to vote. The right to register is the golden key that opens the door to exercising the right to vote. On that note, I say the right thing ought to be done. Yep. Now, this show is brought to you, as always, by Bank of Africa. Are you a public service worker and need a loan to meet that dire financial need? Here is some good news for you. Apply for a loan from Bank of Africa and you are sure of getting your loan approved within 48 hours. Enjoy up to 5 years to repay, get a discount on fees, and ultimately start repaying the loan after 3 months. Yes, that's some good news. Visit any Bank of Africa branch nationwide for further inquiries. Bank of Africa, strong as a group and close as a partner. Are you an MTN postpaid subscriber? Have you ever run out of data in the middle of an important transaction? There is good news for you. You can easily top up your data in 3 steps. Simply dial *138# from your phone. Select Internet Packs, Data Top Up. Choose your data option. Stay connected to your friends and family on the best data network in Ghana. Call 100 or your account manager for further details. MTN Business, welcome to the new world. And Star Assurance, they are the group that ensure that you enjoy endless smiles on your face because they ensure that the dangers that exist in this world appear to you, they don't exist at all. Any insurance policy you're seeking, contact Star Assurance, and that's where you get the best of service. You can log on to starassurance.com or visit any of their offices nationwide. You can call them 030-224-0632 and enjoy solid insurance all round. Prostacure Tea is a special formulated health drink that improves urinary problems, frequent urination during the day, delayed urination, straining during urination, and so on. Prostacure from Medimosis Prostate Center. You can locate Medimosis Prostate Center at Adenta Barrier, Tema, Ajekojo, or Adenta Ahenema Kokobeng in Kumasi. You can call them 020-8140-668 or 0244-068-447. Thank you very much for staying connected. We will take this break and return to continue with the registration process that is going on and the problems that have come up, including the arrest of persons and vandalization of equipment and so on and so forth. We'll be right back. Don't go anywhere.